case. Your Honour, before lunch I tendered two statements of Detective Senior Constable Aaron Ferguson, and I call Detective Aaron Ferguson.
Detective, would you take an oath on the Bible or an affirmation?
Oath.
Oath. There's a Bible there. We should hold it for me. And repeat after me. I swear by Almighty God.
I swear by Almighty God.
That the evidence I shall give in this Royal Commission.
That the evidence I shall give in this Royal Commission.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Yes, thank you. Take a seat.
Can you please state your full name?
Yeah, Aaron Ferguson. Ferguson spelled Ferguson.
Thank you. Now, Detective Ferguson, you've prepared two statements to assist the Royal Commission in these proceedings.
That's correct.
Now, they're dated the 1st of May and the 6th of May 2015.
That's correct.
And are they true and correct to the best of your knowledge and belief?
Yes, they are.
Your Honour, I have no questions for Detective Ferguson.
Who does have questions?
Your Honour, I have questions.
Only you? No one else?
No, Your Honour.
No, very well.
Thank you, Your Honour. Detective, my name is Hall, H-A-L-L. I appear for Mr Rolliston. Detective, in your statement...
Is there a microphone near you? Yeah.
In your statement at paragraph 8, you refer to 6 complaints that were made to police that were not the subject of criminal charges, correct?
That's correct.
And insofar as the allegations outlined at subparagraphs A, B are concerned, those are complaints that you took during the course of the investigation?
That's correct.
And so far as you recall, having checked your records for the purposes of preparing this statement, is it your understanding that neither of those complainants wanted to proceed with matters going to court?
That's correct.
In relation to paragraph C, that concerned a complainant who made an allegation of an incident when he was an adult. Is that right?
Yes.
And as matters currently stand today, you're not entirely sure, or you can't remember why it was that matter didn't proceed by way of a charge. Is that right?
That's correct. I can remember why, because it was the circumstances were somewhat different to our investigation at the time.
And your investigation at the time was concerning historical child sexual assault matters in the course of Dr Rolliston's practice, is that right?
That's correct.
In relation to the further 3 complainants that are set out at paragraphs D, E and F, to the best of your investigations and your recollection of those investigations, is it your understanding that neither of those complainants wanted to proceed with matters by way of a charge?
To the best of my recollection, that's correct.
And those were allegations that were taken after your involvement in the investigation had finished?
Yes, that's correct.
So you're relying on records held by New South Wales Police in relation to the outcome of those matters?
Yes.
And Detective, just for clarification, in your experience as a detective of police, whether a matter proceeds by way of a charge, whether it ultimately goes to court, is influenced to a great deal on whether the complainant wants it to go to court?
That's correct.
Right. And that includes their preparedness to give evidence in court, is that right?
That's right.
And the decision to go to court or to lay a charge is not something the police simply make of their own volition?
No, that's not. That's correct, yeah.
Yes, thank you, Your Honour. That's cross-examination.
I do have one thing to say, Your Honour. Detective, I'm afraid I misled you earlier, and I said to you that there were 2 statements before the court dated the 1st and the 6th of May. In fact, the 2 statements, the first one is dated the 4th of May. Can I just ask you to confirm that? The date is in fact on the last page.
Oh, yes, it is.
Yes.
Sorry.
So,
4th of May, 2015.
thank you.
Yes. Thank you, Detective. You're excused.
Thank you.
I now call Kieran Penn.
Bible.
Yeah, please.
Would you repeat after me? I swear by Almighty God
I swear by Almighty God,
that the evidence I shall give in this Royal Commission
the evidence I shall give in this Royal Commission
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Yes, thank you. Take a seat, please.
Can you please tell the court your full name?
Kieran Tibor Pem, Tibor.
And you've prepared a statement to assist the Royal Commission dated the 22nd of April 2015.
Yes, I have.
And is that statement true and correct to the best of your knowledge and belief?
Yes, it is.
Thank you.
It will be Exhibit 27 and 13.
Mr Pem, can you please state for the Commission what your current position at the HCCC is?
I'm the Commissioner of the Healthcare Complaints Commission
And how long have you had that position?
since the 29th of June 2005.
Okay. And from a day-to-day level, what type of role do you have in the assessment investigation role?
It's varied over time, but consistently I make all the assessment decisions on complaints. The process involves assessment officers marshalling the information, including internal clinical advice, and making a recommendation as to what the outcome should be, and I make those decisions.
Okay. And has that been the case since the commencement of the Commission, that the Commissioner makes that ultimate assessment decision?
I think pretty consistently, yes.
Right. And what about the ultimate investigation decision?
I also sign off the final investigation decisions.
Do you have management responsibility for the office?
Yes, I'm the chief executive of the commission, so I manage all of the finances, HR, performance management, all of the.
What's the total staff of the Commission?
It's varied over time. It's currently about 71 full-time equivalents, about 5 actual staff.
And then on a weekly basis, how many assessment decisions would you be making?
We meet Tuesday mornings and Friday mornings. We get through about 5,000 complaints a year, so I can't do the math in my head, but a lot.
Right. And the assessment officer, having done their own assessment work, will make a recommendation?
Yes.
Is it often the case, or sometimes the case, that you disagree with that recommendation?
Yes. The quality has varied over the years. More recently, it's more reliable. But if I see something in the assessment brief, we call it, which is the recommendation of the assessment officer, and it concerns me, I'll ask questions and go further into it. I might send it back for more work or make a different decision.
Mm-hmm. And what's the training and qualifications of the assessment officers?
Varied background. They're fairly lowly graded, if you like. They were graded 3, 4 in the public sector. They've been upgraded. I think we just look for good analytical ability. We have quite a few law graduates. No formal educational qualifications, just their capacity to analyse, to write. Very important part of the job is speaking to complainants, which we've emphasised more and more as time has gone by. We've moved from a very paper-based approach to a much more active engagement with people. So but most of that comes with on-the-job and training we provide about how to listen to people, how to interact with them.
Right. And they're not necessarily lawyers then?
No.
No. And is that same skill set and experience set the same for the people who do the investigation?
No, investigation is a much more detailed process. I mean, assessment officers will carry 60 or 70 cases at any one time. Investigation officers currently have about 15. It was 20 a while ago, but back when I started it was up around 40, which is too many. Investigation is a much more intensive process, gathering evidence much more intensely, interviewing witnesses, taking statements. Again, with investigations, we've moved from a very paper-based process to getting people out in the field and talking to complainants, getting witness statements. So a different skill set, different training. They've done investigation training, which we've provided.
Mm-hmm.
And again, varied qualifications there. We have some ex-clinical staff, a few lawyers there. We have and have had former police officers as well. The current director of investigations is an ex-English police officer.
Right. Okay. Now, in your statement, Mr. Pem, you'd been asked to, and you have done, provided information about the response to AWC, AWH and AWB, the response of the Healthcare Complaints Commission, and you've set out in a fair amount of detail how it is that the Healthcare Complaints Commission went about that assessment process. So what I'm going to do is just take you through some of that in a little bit of detail. At page 4 of your statement, you commence with the assessment phase in relation to AWC.
Yes.
And at paragraph 19, you state that on the 13th of August, the HCCC received a complaint from AWC, and that's when the file on AWC commenced. Now, towards the bottom...
That's the 13th of August, 1998. I think
sorry.
The year's not unimportant.
No, 1998. Now, towards the end of that paragraph, you've said, Mr. AWC stated he had only disclosed the incident to his family in 1998 and he was seeing a psychologist to assist him. Now, can I ask for the document behind tab 11 to be put up on the screen? Now, this is the letter of complaint, the handwritten letter of complaint that's referred to, and the handwritten letter of complaint that AWC sent. Now, this is a 4-page document, and the last 2 pages is in fact a transcript. So can I ask for the bottom half of the 4th page to be scrolled down to? Thank you. Now, the second last paragraph there in the body of this document, AWC has set out the details of the child sexual abuse that he experienced. And what he said here is, at the end is, this event has mentally, sexually and emotionally scarred me. It has only been this year that I've finally faced this problem. I've told my family and I'm now seeing a psychologist to help me get over it. Could you please assist me as I wish to lodge a complaint against this doctor? Now, in this, AWC is giving the Commission an explanation of the delay in coming to the Commission. Would you consider what he said there to be an adequate explanation of why it is he took so long to get to the Commission and make his complaint?
Yes.
Can I ask you this, Mr. Pem? The issue of delay in sexual assault cases, not just children, but particularly with children, is an issue that's been discussed in the law, and I'm sure you know this for some years now, as to its consequences in the legal process, and particularly in criminal trials. Going back to 1998, could the public have expected that officers of the HCCC would have known of the difficulties of complaint for people who were sexually abused as children, and the fact that it can take a very long time for them to report?
The public would have expected that, and one would expect it.
And the public would be entitled to have expected that?
Yes.
Okay. Now, from the next page, Mr. Pem, paragraph 20, you've set out the HCCC's response to Mr. AWC, and you take, through your statement, go through the assessment phase. Now, can I ask you to turn to page 6, and at the top of page 6 is paragraph I.
Yes.
Now, there you say, on the 22nd of October 1998, an HCCC legal officer wrote a memorandum to the Commissioner observing that, having regard to the extensive time that had elapsed since the alleged incident, the HCCC had a discretion to discontinue the complaint under section 27(1)(f) of the Healthcare Complaints Act. Now, Mr. Pem, section 27, subsection 1(f) of the Healthcare Complaints Act, in fact, doesn't stop there, does it? There are two parts to section subsection F.
Yes. And if I read out, the complaint relates to a matter which occurred more than 5 years ago, 5 years before the complaint was made, and the complainant does not have a sufficient reason for having delayed the making of the complaint.
Yes, and that's correct, and that's what I was going to take you to next. I took you earlier to the part of AWC's complaint where AWC made an explanation of why it is it took him so long to make his complaint. Would you consider that that constituted an adequate explanation?
Yes.
Yeah. And to that extent, section 26(1)(f) isn't invoked?
If you accept that there is a sufficient reason for for the delay, then no, it doesn't operate.
Which you do today.
Yes.
Thank you.
Can I ask you this? This is a bit out of sequence, I know, but it's an important question. As I understand it, when you get a complaint at the Commission, the complaint is required to be notified to the Medical Council, is that right?
Yes.
And the Medical Council have the power to act straight away, don't they, on receipt of the complaint?
Yes.
Now, what would happen today if you got a complaint from an adult that they'd been assaulted by a doctor as a child, and the doctor was still practicing? The complaint would be reported to the council.
Yes.
Could we expect that the council would take immediate action?
Well, they would take some sort of immediate action. The extent of that, I suppose, is for the council to...
Well, obviously so, but in your experience, what could we expect might be done?
Well, the response often in sexual misconduct matters is she's chaperone conditions.
Right. Until the matter's resolved.
Until it's investigated and that reaches finality and either prosecuted or not.
And you could expect that as an immediate response in relation to an allegation of sexual assault of a child.
Yes.
Thank you. Could I please have up on the screen the document behind tab 23. And Mr. Pem, this is the document that you referred to here in paragraph I.
It's on page 6, isn't
Yes,
it? Yeah.
that's right. And you can see the date there. It's been the 22nd of October.
Yes.
Right. Can you just scroll a bit down the screen, thanks? And scroll onto the second page and to about halfway down the page if you keep going. A bit further down. Oh. Oh, right, that's right. Now you can see there at the paragraph starting clearly, here the legal officer or the officer has said, clearly having regard to the extensive time that has elapsed since the events about which Mr AWC complains, the Commission prima facie has a discretion to discontinue dealing with the complaint under section 27(1)(f). And again, taken by itself, it's not clear where you stand today that in fact the Commission does clearly have a discretion.
Well, I think if, as I said before, if you accept that there's a reasonable, if there's a good and sufficient reason for the delay, then the Commission wouldn't have a discretion.
Yes.
But I suppose in considering whether there's a sufficient reason, there is discretionary factors. But yeah, I take your point.
No. And what's happened here in that statement is that this officer has made that interpretation and come to the conclusion that a discretion arises, whereas today you might look at it and have a different interpretation and say a discretion doesn't arise.
Yes.
Now, can we turn the page to page 7 and go to paragraph N? Now, this is where you say, on the 11th of November 1998, the Assessment Committee assessed the complaint for investigation. It was noted that there was an issue due to the age of the matter and as to availability of evidence for disciplinary action. And the committee also requested that the legal division advise as to A, suitability for referral to police, B, obligations to report the sexual abuse to DOCS or other investigations. Now, Mr Pem, I've had a look through the documents available and I haven't been able to find a response to this. I found a response which is in September 2001. Are you aware of any response to this request before then?
No, if it's not here, then I wouldn't be aware of it.
Okay.
And we wouldn't have found one, I would presume.
Okay, thank you. Now, further down the page there, Mr Pem, at 21, paragraph 21, you've set out there the first steps of the investigation that are commenced. And I just point out that this is commenced 10 months after the decision to investigate. Now, is that standard or is that unusual?
It's very poor, obviously. It's certainly not standard now. I wasn't there then, but when I arrived at the Commission in 2004, it was not uncommon to see delays of 2 and 3 years in files.
So that's delays of 2 and 3 years between what point?
Between any action being
between
taken.
complaint received and any action being taken?
Well, no. More generally, something might be an investigation and have got to a certain point, and then there could be a delay of, would there be 2 years where there would be no action taken?
No resolution then?
Or no action taken at all. So it's still on foot. It's still an investigation, and that's what we had to come to grips with.
It's sleeping in a cupboard somewhere.
Well, they're actually piled up in a big corner office there are probably 700 or 800 files in it that were unallocated.
Over what period of time have they been accumulating?
Probably 3 or 4 years. I think it seemed that the Commission had there was too much work, and the investigation officers decided they'd have a limit on the number of files they took, and those that weren't, if their file limit was exceeded this, they lay fat on.
How did you solve that problem?
With a whole range of responses, and a whole lot of management systems and structures needed to be put into place. We have very poor information systems, so we relied on creating team structure, sort of teams of 3 to 5 people with a team manager. So at least you could get some sense of, it was a very flat structure before that, and everything was pretty much left to the discretion of the investigation officers. So then training, we had to implement a completely new case management system. The one they had was very poor. So a whole range of things across the whole organisation. And it took a long time to sort through those things.
Can I just ask you to move your microphone just a little closer to you? Apparently you're a bit hard to hear.
Right, sorry.
Thank you. Now, Mr. Pem, if you turn the page to page 8, and the first paragraph is paragraph B there, we've said, on the 26th of April 2000, Mr. AWC contacted the HCCC by telephone. Now, I guess I'm just picking up on what you've just candidly said about files sitting on people's desks. And there's certainly numerous instances here where there's been no contact between a complainant and the HCCC, and in fact, it's been the complainant that has once again initiated the complaint.
Yep.
That's probably an example of that, would you say?
Yes.
So again, that's another 7 months later. Now, on the 1st of May, an officer of the HCCC contacted Mr. AWC and gave him an update and apologised for the delay. And the officer explained the matter might not proceed as no response from Rolleston had been received. Now, if the HCCC is considering not proceeding with a complaint on the basis of a lack of response from an alleged perpetrator, wouldn't it be at this stage that the HCCC ought to have been thinking, well, we can't do anything about this because we're constrained, we need to wait from this alleged perpetrator. It's time that we made a referral to the police?
Yes, that would be one way of dealing with it.
Well,
there are other investigative steps could have been taken. The evidence of complaint to family and to psychologists and so on. But yes, referral to the police could and should have been considered. Yeah. Well, I suppose I'd better qualify that. I think the Act was perhaps unclear at that stage as to the Commission's power at that time in the process to refer to police. Well,
the power to refer to police at certainly the power under Section 26 to refer to the police at the end of the assessment process has been there since the commencement of the Act, hasn't it?
Yes, it has, but this complaint was in investigation, so the end of the assessment process had finished and it was in investigation. And I think Section 99 was probably the applicable law about not disclosing information except for the purpose of discharging functions under the Act, and there's a proviso with other lawful excuse. Now, referral to police would probably be lawful excuse.
Sounds like it might be, Mr. Pym.
Yes.
But Mr. Pym, can I just ask you this? I'm a lawyer, so maybe that's a problem. But how could it ever be, if you have a complaint, but you haven't had a response from the person complained about, that's a reason to discontinue any investigation? It defies belief.
Yeah, I agree.
Now, further down the page at paragraph F, you've said, it appears from the file that no further action was taken after this time until the 30th of July 2001, again where Mr AWC contacted the HCCC by telephone. And this was around 3 years after the initial complaint was made. And you certainly again said here that there's no reasonable explanation for this delay. Is the only explanation for the delay you've got to give the one you gave earlier, that the file was perhaps sitting on somebody's desk? Or is there any other explanation besides that?
No, I can't be any more specific than that.
And I think the question's been asked already. Could that happen today?
No.
You've talked about staff allocation and a sort of distribution of resources. Is there any kind of electronic checking system?
Yeah, there's a case management system now. So when a file goes into investigations, there's a 3-monthly monitoring report. There are a lot of processes. Investigations have to compile an investigation plan within a set period, and if that's not done, an exception report's produced so that the team manager's aware of delays and can address them. There are a lot of checks and controls in the case management system that would prevent this happening today.
Okay. In relation to the assessment phase, there is that 60-day turnaround time that is said to occur. Now, there's no similar provision in relation to the investigation phase, is there?
No.
Is there some standard guideline that the HCCC uses to guide what is a reasonable amount of time to...
Well, our current key performance indicator is 90% of investigations completed within 12 months. We set at 80% when I arrived at the Commission, and I can give you some details about how long things actually take. Simple things are quicker. But there'll be very few investigations run over 12 months now.
Right. Are you able to say whether at this point in time there are any guidelines or, I don't know what the phrase you used, key indicators?
There may have been, but if there were, they weren't being observed.
Okay. It's been noted that the AWC's complaint when it came to the Commission was a 19-year-old complaint, and reference was made to the fact that it was an old complaint. By this time it had become a 22-year complaint, hadn't it?
Yes.
Now, on page 9, and I ask you to go to paragraph 8, H, there appears to be a response to a request, and I think this is the one I mentioned earlier, to the request that was made earlier in relation to potential reference to the office of the DPP.
Yes, which was 3 years earlier.
That's right. And that's the first response I could find in all of the documents in relation to it. Now, you've said here on the 12th of September 2001, an HCCC officer prepared a memorandum advising that the HCCC may refer the matter to the office of the DPP, but to check with the complainant first to ascertain his wishes in that regard. Now, that didn't happen, did it?
No, not as far as I know.
Now, further down the page, we've got paragraph J, and you've said on the 26th of September 2001, the HCCC officer finalised an investigation report. And at the bottom of that paragraph there, you've said that the report observed that after 22 years, there was no longer a public interest in taking disciplinary action. Can you tell me, just expand on what concepts that public interest has?
What generally do I understand to be public interest?
Yes.
Well, some good public purpose to protect. I'm not sure where the term comes from. I mean, the term used in the legislation, I understand it's always been that way, is to protect the public health and safety. And clearly there'd be good reasons in a case like this of risk to public health and safety.
Yes.
So I don't know what they mean and why they use the term public interest.
Okay.
Can I just understand this paragraph a little more? The report identifies, you record this in the beginning of J, that this was a serious allegation, and it plainly was. And if proven would result in disciplinary proceedings, that so much is clear. At this stage, it's a complaint in relation to a practitioner who's still practising with the potential for risk to other children. Was that, in your view, a relevant factor?
Yes.
At that hearing?
Yes.
Now, it's then said, given the long delay, Rolleston wasn't able to adequately participate in his own defence other than to deny. Now, when you have an allegation of a doctor abusing a child in the consulting room and there's only the two of them present, will there be any other action that the doctor can take
Other than
to
to
deny?
No. Well, they can admit, but...
Sorry?
They can admit. But
Admit, yeah, but if he's going to defend, there's very unlikely to be anything else, whatever the time be.
well, unlikely there'd be any medical records, yeah.
Well, making the assumption there's a record that the patient was there in the first place, which you would expect.
You would expect the doctor to deny it, yes.
But there's little else the doctor can do or say in aid of the denial.
That's right.
Now, it said there are competing or public interests of protecting the interests of the practitioner and maintaining confidence in the administration of justice. Now, is it part of the public interest to protect the interests of the practitioner?
No.
But we, I think, can see why confidence in the administration of justice might be important.
Yes.
But are we talking about the administration of justice here?
I don't understand the question.
Well, I'm just wondering whether it's correct to describe the process which was then being engaged in, that is investigation, and whether or not to proceed, as involving the confidence in the administration of justice.
Oh, probably not. I mean, they could equally seek confidence in the proper administration of the legislation and the public health and safety.
Well,
it's probably a misuse of the...
And part of that, of course, was to ensure an efficient dealing with the complaint.
Yes.
Can you see any countervailing problem?
No, I can't. I can't. I mean, I suppose to give you some context and why I think that might have been written in the way it is that the Commission's always been in this very contentious space between health consumers and practitioners, and it's a highly contested and disputed space. And in fact, I don't have the current version of our Act, but recently, on the recommendation of our parliamentary committee, yeah, I do actually. Section 3A5B says the Commission and other government agencies in carrying out those functions are to have regard to the following principles. And C is an acceptable balance is to be maintained between protecting the rights and interests of clients and health service providers. So there's always been this, and it's sort of swayed over the years as to what's our role and whose side are we on. And the view of, not uncommon view amongst health practitioners is that we're on the side of complainants and against them. And so I think that's maybe behind what they're trying to say there.
Well, the starting point for your existence is that there's a complaint.
Yes.
And the assumption must be, at the very least, you, the Commission, will effectively resolve that complaint one way or the other.
Yes.
Now, the report you say observed there was a real risk of a successful application for a stay, given the delay. Now, what's your perspective on that? If is that relevant, or is it a matter that's to be left to the tribunal?
Well, it's a matter to be left to the tribunal. I think, I mean, although this wasn't applicable at the time, one of the criteria that the Director of Proceedings has to take into account in deciding whether to make a complaint to a tribunal is the likelihood of proving the complaint.
Yeah.
It's certainly premature in this at this stage.
Well, in terms of proof of the complaint, you passed the observation that it was concluded it was unlikely that a complaint would be proved to the necessary standard of proof. Now, I assume that's a reference to Brigginshaw, as we understand. Is that right?
I assume so.
As you see it, what were the difficulties at that point in proving the complaint?
I think would be the difficulties would be the delay and the issue of credit. It would be purely, well, it's not purely, but largely on the credit of the two parties.
Well, with a sexual assault case, which hopefully you don't see too many of, it's very often down to the credit of the...
Yes.
And you have to let a tribunal resolve it, don't you?
Decisions are made at the prosecution stage not to do that. It might be on the basis of a assessment by counsel of the credit of a witness, that there's no reasonable prospect of taking it to a tribunal.
That may be so, but is there any suggestion here that there was any reason to doubt the credit of the complainant?
No. No, and I'm not suggesting there is.
No, and when you're in that position, given that they're almost all going to be one-on-one allegations, is it the role of the Commission to cut off the process because it's a one-on-one situation? If you have no identified reason for doubting the credit of the complainant.
Well, leaving aside these particular cases, we have an allegation might be made by a patient who's under twilight sedation on midazolam, which occasionally has the side effect of sexual hallucinations.
That's a circumstance where you may have reason to doubt the credibility.
Well, no, I mean, the complainant believes, and absolutely believes what's happened, but 6 witnesses in the operating theatre say no. Now, that's not something you would put before a tribunal.
I understand that, but when you don't have reason to doubt the credibility, but it's still one-on-one, what would you do?
Well, it should go to a tribunal or to a disciplinary body.
Yeah. And the final point which Council took you to is that the comments made after 22 years there was no longer a public interest in taking action. Well, that's in the context of a person who's still practising, isn't it?
I'm not sure what that means or why that's there.
It doesn't attract you as a sensible proposition, I assume, in these circumstances.
Thank you. On the next page, at page 10, Mr. Pem, paragraph K, was stated on the 28th of September 2001, an officer of the HCCC contacted Mr. AWC by telephone to explain to him the reasons for the proposal not to proceed. Now, there's a file note of that conversation behind tab 48, and I ask that that document be put on the screen. Now, this is a file note from the conversation that took place between Mr AWC and the officer of the HCCC. Can you just see there at the second paragraph, the officer has said, he said that if no action was going to be taken, he was going to go to a private solicitor and take civil action. He was awaiting the outcome of what the Commission was going to do. I said I would be recommending that the complaint not be referred to the police or Department of Community Services for the same reasons outlined above. And I just pause there. When he says outlined above in the first paragraph, he said he would be recommending no action due to the age of the incident. There is no longer a public interest in pursuing it after such a long time, and there'd been no other complaints of this nature against Dr. Rolleston. So they're the reasons. So he said he wasn't going to be making the referral to the police or docs for those reasons outlined above and the difficulties in proof. I asked if he considered going to the police. He said he might and wanted to know why it would not be referred. I again stated the reasons. Now, here, not only is the Commission, the Healthcare Complaints Commission, not referring this matter to the police, but in a sense, in how it's being put to the complainant, he's disencouraging the complainant himself to go to the police.
Yes.
It's also the case, isn't it, that while the Healthcare Complaints Commission may investigate a matter and can properly investigate a matter that relates to what is potentially a serious criminal offence, it's not the case that the police have an identical set of powers and would carry out an investigation in an identical manner with identical priorities, is it?
No.
Yeah. So if the Healthcare Complaints Commission's had no success in terms of investigating a complaint, there's nothing to say that the police won't be successful.
No.
And of course, down the page there, we know that ultimately the complaint against that made by AWC was terminated.
Yep.
Now, on page 11, at the top of the page there, paragraph 23, we've got, there's a heading of further assessment of the file in relation to Mr AWC. On the 23rd of November 2006, the board, and that's the medical board, wrote to the HCCC noting a telephone conversation with AWC in October of 2006, in which Mr AWC indicated a willingness to proceed with the complaint. Now, the medical board had made a link, hadn't it, between the complaint of AWC and another complaint. Now, this was a complaint that, in fact, the HCCC was investigating, the complaint of AWH. You'll see underneath it, it says, the board noted current investigations by the HCCC in relation to AWH.
Yes. Sorry, I'm just getting a bit confused with the...
Yes.
Yes.
So my question is, why isn't it that the HCCC didn't join that link itself, even before the medical board did?
Yes, it's a good question, and the Commission didn't. And I can again only point to the poor information systems available at the time.
Right. So is it the case in 2006 there wasn't an electronic sort of tagging system by which somebody's name can be put into it and a single perpetrator or respondent can be identified?
There was a case management system, and I think that it could not be done easily. And I think there's another document we produced, which is a memo from Ruth Robinson, who was the manager of assessments at the time, and she actually did identify the earlier complaint.
Okay.
At the assessment of AWC's complaint.
Right. Good. Right. So again, further down the page, you've just set out the second investigation stage in relation to Mr. AWC's complaint. Now, if you turn the page at page 12 and go to paragraph 8, you've said on the 16th of April 2007, it was decided to defer seeking legal advice until the matter concerning AWH's matter was at the same stage. So it was at this point that the two matters of AWH and AWC started to become interleaved.
Yes.
Now, what you've got now at this point of the investigation are two complaints of a similar nature. In fact, three complaints in a sense, because you've got AWH's brother, AWO. So you've got three people who are alleging sexual assault by a doctor who's still practicing medicine with access to children. Now, you clearly are proceeding with your own investigation, but again, at this point, once that link has been made, wouldn't it have been appropriate to make a referral or share information with the police?
Yes, it would have.
And again, is the threshold of referral to the police in relation to these types of issues, is the threshold for referral lower these days than they were back here?
Yeah. When I started around 2004-05, there was no practice of interaction with police. We would get the odd complaint referred by police, but it became clear, largely through coronial referrals because of deaths in hospitals and so on, and we would get requests from police at the coroner's office, and rather than requiring them to produce a summons to compel our records, we entered into this memorandum of understanding with the New South Wales Police in April 2005. And from that time on, the exchange of information became more frequent and fluid.
Right.
Although I do know this is some 2 years later, and it doesn't seem to have occurred to us to refer the material to police at that stage.
Mm-hmm. Now I'm going to take you to the assessment of the complaint of the AWH now, Mr. Pem. That's at page 14 of your statement and paragraph 26 of that page. Now, it was on the 9th of May 2003 that the HCCC received a complaint from AWH. And the complaint was made specifically in relation to a medical practitioner named Dr. Rolleston, who practiced at St Ives. Now, since the 4th of November in 1998, the HCCC was aware of the name of John Philip Rolleston in relation to the complaint of AWC. This is 2003. Why wasn't it immediately connected that, in fact, this was a complaint about the same person?
It should have been, and I don't know why it wasn't.
If you turn to page 15 of your statement and go to paragraph H, Mr Pem, you've said it, on the 25th of June 2003, an officer of the HCCC had a telephone conversation with Mr AWH, and he was agreeable to providing a statement and that he would ask his brother also to do so. He said he'd not been to the police about the matter and had never given a statement about it. And again, certainly the issue of the police was raised, but not in a positive, encouraging type of way. In addition, just in terms of what's happening now with the Healthcare Complaints Commission, in addition to making a referral of a complaint itself, of course, there's another avenue by which a complaint can get to the police. Is it the case that complainants are encouraged to go to the police?
Yes, I mean, the first thing we would do if a complainant criminal conduct is raised is discuss it with the complainant and ask them if they've been to the police. And if they haven't, we do encourage them and suggest that they should, because it is it's a criminal matter. It can be complicated where they don't want to go to the police. Well, I think I've said it towards the end of my statement, some of the complications that can arise there, so you might come to that later. And whether you refer something to police without a complainant's consent, I'm not sure that we have done that, that we do that.
I don't know whether you heard the evidence of Detective Slade earlier today, and the detective was saying that the police are able to take information in relation to an alleged perpetrator and take it anonymously, and in fact that information can be used confidentially but highly usefully, even if there's not a name tagged, it's an anonymous.
Yes, I heard that.
Yeah.
And that's good. We sometimes get complaints from mandatory reports from practitioners who say that, you know, even raising this matter with the complainant would damage her mental health. And we try to talk through that. Sometimes the practitioner will persuade the client to talk to us, and we have persuaded people to go to the police in that situation.
Your Honour, I'm loath to interrupt, but just for the integrity of the record, there's a couple of times that my client has nodded, seemingly agreeing with a proposition put by counsel assisting, but it's unlikely, that response is unlikely to be transcribed. But perhaps just for the record, if he means yes, say yes rather than nod, it might be helpful.
I'll try and do that.
Just on that topic of referrals to the police, Mr Pem, and protection of the public, it is the case that the Healthcare Complaints Commission will get complaints made to it in relation to medical practitioners or other health practitioners, and it will be a complaint potentially made of improper conduct carried out in the course of the profession of that medical practitioner.
Yes.
Or health practitioner. thinking about the protection of the public more broadly, there will often be cases where the Healthcare Complaints Commission can't be satisfied at any level that, in fact, that is the only context a perpetrator carries out that conduct. So, for instance, if a doctor sexually abuses a child in the course of examining them, that doesn't mean that the only time that that perpetrator sexually abuses children is in the course of their work as a doctor.
No.
Now, that has implications, doesn't it, in terms of how appropriate it is for the Healthcare Complaints Commission to hang on to a complaint itself, as opposed to hanging on to it but also referring that on to the police, who will be able to deal with it at a broader level.
Yes. Well, we also get complaints that are not in the conduct of the profession, which are not required to be mandatory reports, but a recent one is a person who complained that her father had sexually abused her as a child, and she wanted to stop, to, you know, concerned that he was doing, now a nurse, and she didn't want to have to do other children. And she has gone to the police.
Yes.
We talked to her, and that was the one that came to us from her medical practitioner with, you know, don't talk to her, she doesn't want to go to the police, and she's gone to the police.
Mm-hmm. Thank you. Now, on pages 16 and following that, you've set out the steps that were taken in relation to the Healthcare Complaints Commission attempting to obtain a statement from AWH, and that wasn't successful. For example, at the bottom of the page, of page 16, paragraph E, the Commission set out the steps in terms of sending an officer to Murwillumbah, and for one reason or another, the complaint wasn't there and it didn't happen. On page 18, at paragraph J, you set out that on the 10th of December 2003, an officer of the Healthcare Complaints Commission contacted AWH by telephone. Mr. AWH was advised that the Healthcare Complaints Commission had not received any further information and that there were two options available, and that was namely to discontinue or to terminate. Now, again, could you just, the basis of this was needing to obtain a statutory declaration.
Yes, up until 2005, the Act required any complaint that was assessed for investigation to be supported by a statutory declaration from the complainants. And again, I think the genesis of that was this the health perception that many complaints were unfounded and vexatious, so they wanted them to be verified in that way. And that was removed in 2005.
Again, in a situation like that, where there's a sort of a statutory roadblock to an investigation within the Healthcare Complaints Commission, again, it might be appropriate at that point for them to be referred to the police.
Yes.
Further down the page there at paragraph L, you've said it on the 17th of December 2003, the board wrote, and again that's the medical board, wrote to the then acting commissioner. Now, the letter there advised that the conduct subcommittee considered the HCCC's letter on the 26th of November and the investigation report, and that the committee noted its concern as to the serious nature of the complaint and that there'd been a serious complaint of a similar nature. So again, this is just highlighting the awareness of the medical board at the time that this just wasn't a single complaint, but rather there was this complaint here. But in addition to that, there was the 1998 complaint of AWC and his brother that hadn't been resolved.
Yes.
Again, all the more reason to sort of have regard to the seriousness of it and perhaps to have considered the police.
Yes.
Now, across the page on page 19 at paragraph 29, there is the assessment of the complaint in 2006. So the complaint of AWH's was discontinued as opposed to terminated. And then on the 10th of July 2006, the HCCC received a further email from AWH. Now, he advised that he had suffered a nervous breakdown since 2003 over many things, and including the issue to do with Dr. Rolleston. But he was in better health and wanted to pursue the matter again, and even if it meant going to the police to have Dr. Rolleston investigated. Now, the investigation you've set out at paragraph 32, this is the investigation phase that commenced after that initial assessment. So you've said here on the 2nd of August 2006, the file was allocated to an investigator. Now, there was a file note or a memorandum by that investigator. That's behind tab 91, and if I could have that document on the screen. Now, before I take you to the part of that memo that I would like to, I would like you to be refreshed by some of AWH's evidence from yesterday. Now, he said at paragraph 48 of his statement, "It was and still is my strong opinion that the HCCC did not want to help me and wanted to discourage me in pursuing my complaint."
Yes.
Now, just hold that thought, and I'll take you to this memorandum where it said, and this is on the 3rd of August, "I perceive great difficulties with this file. It's a complaint about a very historical sexual assault. There is an IR in the file that Angela O'Gorman wrote indicating potential difficulties. I'm in full agreement with Angela. We should go through the process, but we shouldn't dilly-dally about it. We have to put the allegation to the doctor. I can predict his response, but I'll leave it to the investigation. The passage of time is a serious difficulty here. The complainant alludes to what I can most neutrally say are emotional problems. This should be dealt with appropriately and expeditiously."
What's the handwritten material?
I perceive delay to be our biggest hurdle. I'm not sure whose it is.
Now, I think
I should be prepared to enter a very objective something in the report.
By this stage, about 8 years of delay has been the healthcare complaints.
Yeah, I mean, it's very badly. I mean, it's... I mean, one thing I tried to do was, Scott Sheridan was the Director of Investigations at the time, was to give direction to investigation officers, and unfortunately that's the direction that they got.
So Mr. AWH was pretty spot on, wasn't he?
Yeah.
Now, at further down in that paragraph 32, Mr. Penn, you've said, for my review of the records, the investigation officer emailed me on that date noting he did not consider a telephone interview as an option given the nature of the complaint and welcomed any direction. I responded asking why Mr. AWH couldn't put his complaint in writing and that I didn't see the need to arrange a further meeting given his failure to attend. Now, I've seen what you said there, but would you like to say something about that?
It's completely to my discredit, and it's completely contrary to everything I was trying to do in the Commission. So it is no excuse for it, and it wasn't an appropriate response. I suppose to give it some context, you'll see I responded very quickly to the email. Part of the problem with the Commission was delays, and I sort of developed a practice of trying to keep things moving and getting decisions made. I also say in that email, I'm not familiar with this file. I was on leave when that matter was assessed for investigation, so I wasn't aware of it. But it's indefensible. It just doesn't take any adequate account of the circumstances of AWH's position. And there's no excuse for it.
Now, at paragraph 33, you've said, on the 11th of August 2006, the HCCC wrote to AWH requesting further information about his complaint. The letter advised before the HCCC could commence its investigation, further information was required in relation to 9 separate identified points. A reply paid envelope was enclosed, as well as a blank authority allowing the HCCC to obtain medical records, and a reply was sought within 21 days. Yeah. Now, again, given what you've just said, it's
a completely inadequate response, and I heard Mr. AWH's evidence on the position they put him in and the onus it put on him to do the investigation for us, to get all that information together. And again, how discouraging that was for him. And it's an inadequate and inappropriate way to handle a matter like this.
Now, down to paragraph 35. On the 30th of August, Mr. AWH emailed the HCCC and said that he'd been distressed since receipt of the HCCC's letter, particularly in relation to the request for details such as times, dates, etc. Could I ask for the document behind tab 96 to be put on the screen, please? Now, I ask that you scroll down to the second half of the page to start with. Thank you, you can stop there. So this is the email response sent by AWH, and he says, hello, I got your letter. I was so distressed by the questions asked 3 times, dates, clothing worn, etc., when Dr. Rolleston molested me, that I felt it hard to even think about anything else since receiving your letter. Also, I feel that regardless of what I say, he'll get off. because I was just so young and traumatised by what this bastard did to me and my brother. Now, he's disclosed his emotional responses, his distress and his upset, but he still had a crack at providing the details that were sought. So he goes in a nutshell, and then he's got 3 paragraphs doing the best he can in relation to responding to that. Now, can I just get you to scroll down a little bit more so I can see the paragraph commencing now? Then he says, now, how I prove this, how I have evidence of this is alien to me. I've only within the last few years or so talked about it. Every time I've tried to commit suicide, I never tell the shrinks why. The time as a young man when I tried suicide, not long after he did this to me, I never said why. In fact, I've hardly ever spoken about it. I mean, this guy is just pouring out his emotions into this email. Now, can I ask that we scroll to the top of the page here to see the email response from the Commission? You can stop there, thanks. Dear Mr. AWH, thank you for your response to the Commission's request for information. I apologise for the delay in acknowledging your email, but I've been on 3 weeks annual leave. The Commission will consider the information you have provided, and so on. Now, you've heard the evidence from AWH, how devastated he was at this response.
Yes.
Have you got anything to say about that response?
Well, I can understand. I understand why he was devastated by it. It's very cold, clinical, unresponsive, and sort of don't call us, we'll call you. It's completely inadequate and made no attempt to communicate with him in any meaningful way.
Yeah. This is probably the appropriate time to ask. I mean, the staff at the Commission, who might be legally trained or not, but the staff, whether they're at the assessment phase or they're at the investigation phase, are perhaps often in positions where they're dealing with highly traumatised people.
Yes.
Dealing with them in a way that they themselves have the potential to increase that trauma.
Yes.
What training or support do the staff have in relation to being able to cope with that type of response?
Well, at that time, none. And I think staff, they do deal with a lot of grief and trauma and really deep emotions, and things like the loss of children in childbirth and really traumatic things. And I think they'd sort of become defensive and not engaged, because dealing with that level of emotion constantly and engaging with it to the level of attention that it requires is really difficult. And it was not something that the Commission had any regular training for. There has been training on that issue after this what occurred, but that's how it was.
And what training is there now, Mr. Pem? I mean, I think this is a perfect example of, you do get the sense that the officer of the Commission was a bit overwhelmed and just shut him down. She was ill-equipped to deal with this complainant talking about his suicide and very deeply personal, intimate problems. What's happening right now to assist officers like that?
We've engaged quite an experienced psychologist who trained specifically on dealing with people who have suffered trauma and in grieving or have high emotional load. I can't give you the name of it at the moment. I can provide that to you later if you.
Thank you. Now, at paragraph 37, you've said, and that's on page 21, on the 19th of September 2006, an investigation report was prepared recommending that the investigation should be terminated as the information provided by Mr AWH would not be sufficient to allow Rolleston to provide an informed response other than a bare denial. I think, in fact, the questions asked by His Honour earlier perhaps cover
yes,
that.
Again, and in these situations, that's the only evidence you're likely to get. And again, to our discredit, we left it at that time.
Mm-hmm. Now, also raised later in that paragraph was what you've said to be the perceived lack of corroboration. Now, it's not just, do you consider corroboration the fact that at this point there are 3 people who've had similar experiences?
Well, again, this was a real deficiency in our systems. We talked earlier about the failure to link up the prior complaints, and if you read the investigation report from that officer, it makes no mention of the other complaints either. It just talks about the Mr AWH's complaint. So again, we didn't. One part of the commission had put it together, but then another part of the commission had not made the connection, because clearly in that circumstance there was two others survivors. So, and that alone should have prompted further investigation.
Yeah.
And again, I signed off on that letter to the medical board, I think, at that stage, and I did it on the basis of the investigation report. I always read the investigation reports, and so if I was concerned about anything in it, I'd go further into the file. Again, a mistake on my part not to have looked further into that matter at that stage.
Mm-hmm. Now, if you turn to page 24 of your document and go to paragraph 59, you've stated there that on the 20th of July 2007, an officer of the HCCC sought further information from AWH by email regarding his knowledge of any other complainants against Rolleston and contact details for AWH, his sister, and at that point, and probably only at that point, was in terms of corroboration and disclosures to other people, that it's at that point, in fact, that the HCCC is starting to get into the act of getting more evidence.
I think that's right. I think at this stage, after the medical board put together the other complaints and did not agree that it should be terminated, and I became aware of the other complaints, the investigation finally, after all this time, started to be done more seriously.
Mm-hmm. Mr. Penn, you heard the evidence of the survivors yesterday and this morning, And I probably think all of the survivors who had contact with the Healthcare Complaints Commission have been critical of how they were treated and the processes they were that often they didn't understand. AWA, for example, said at paragraph 52, in relation to correspondence, he was saying, after receiving the letter, I was confused. And a number of the complainants have talked about the correspondence they've received from the HCCC and how there's legislation referred to, there are legal terms referred to that they simply don't understand.
Yes, I saw that, and that's completely justifiable response and perception of theirs. The letters are very bureaucratic. I think it's again the Commission being careful to rely on its powers and its laws and be specific about those. As I said, this area is highly contested, and medical practitioners contest complaints vigorously. It obviously doesn't speak to people who aren't familiar with legislation and law and systems. We've developed, I think we call them fact sheets, which I think we've provided you with, that explain in plain English what the process is at each stage and what the terms mean and how long things are expected to take and when they can be expected to to be contacted again about it. But that, I think we've had those from about 2012. As a result of general feedback from people that the communication was poor and not responsive to them.
Right. So in addition to maintaining the sort of technically precise letters that do go out and comply with the legislation, for example, in addition to that, there are plain English versions.
Yeah, there are attachments that go out with the letters. Also, there's a practice now, which I'm sure is in the investigation procedures manual, for the investigation officer to call a complainant before that, in these sorts of sensitive, highly charged situations, for the investigation officer to discuss with them what they can expect to receive and answer any questions and contact numbers there. So we put effort into trying to make the process more understandable to people, which is not to say it can't be improved more.
Well, I mean, in terms of, again, the evidence, I'll actually come to that because I'm going to take you to some of the things that the survivor witnesses said in their statements and giving you the opportunity to directly respond to that. Again, AWA, in his statement at paragraph 69, said, in relation to the correspondence from the HCCC, all it would have taken was a phone call from the HCCC from the start in 2009 to say who they were and what they were that they were interested in pursuing against Dr. Rolleston, what my involvement was, that they would be sending me some emails. Instead, I spent 4 years asking the same questions and getting no satisfactory answers.
Yes, I saw that evidence, and it's poor practice by the Commission, and it's very unsatisfactory for AWA, clearly.
He also said, my overall impression from my contact with the HCCC was that there was no continuity and it was very impersonal, with no cohesive central contact point or person. These factors added to the frustration and lack of trust I felt towards the HCCC. Who the HCCC are and what their agenda was lost in the legal rhetoric, which was also quite intimidating.
Yes.
So in terms of if you like, humanising the HCCC, the HCCC is always going to have the difficulty. It is a statutory-based body that needs to carry out its functions in a highly procedurally based manner. What steps, in terms of specifically addressing what AWA has said here, how do you think it might be personalised, if you like? And he's made the complaint here about a central contact person or point.
Well, it's certainly the contact, the people contact is the essential thing. It's very difficult to organise one person to see a complainant through the whole process because of the different, I suppose, roles and skill sets through that assessment, investigation and prosecution phase. But everyone who deals, I mean, and there were staff turnover issues there as well, so that was sort of unavoidable. But everyone who deals with a complainant should maintain regular contact with them and be prepared to, well, firstly explain to them what's happening and be prepared to answer any questions. I mean, when I started the Commission, assessments, it was an industrial issue about even giving out names and contact numbers. And fears were raised of, you know, being stalked and harassed, and so we had to go through a whole process with, you know, the PSA, and finally, you know, it was agreed that they would talk to people and give them their names, give them their telephone numbers in correspondence. I mean, it's terrible to look back at this, and it's terrible to see so closely the impact that it's had on the survivors here, and no doubt the adverse impacts and the alienation that it's caused to other people that have had legitimate complaints and haven't had them dealt with properly. We've tried to improve the customer service angle and the contact and the explanations that are provided. And particularly in AWA's evidence, I noted he tried to get onto the medical board website to you know, see what might happen now about a complaint of this type. And we've put a lot of work into the website to explain the process and what happens, and electronic complaint forms. I mean, over 50% of our complaints are now electronically lodged. So this is bad, and it's indefensible. And I don't hope. I'm sure the Commission is much better now than it was then. But that cultural change process is something that takes time and takes training, and takes some staff deciding it's not for them. And the Commission went through a very difficult time for the first probably 5 or 6 years I was there. Not that that's an excuse.
Now, AWC gave evidence earlier today, and at paragraph 48 of his statement, he said, on or around the 17th of August 1998, I received a letter, and then he says from an HCCC officer. The letter acknowledged my written complaint and enclosed a brochure entitled Sexual Misconduct. And this was a leaflet guide on making a complaint about a physical or sexual assault, or about a sexual or inappropriate relationship by a member of the health profession. Now, and then he goes on to say, I remember feeling again like I'd contacted the right body and the right professionals to help me with my complaint. Now, I ask that that document is behind tab 14, if you could get that up, please. Are you familiar with that document, Mr. Pem?
No.
Okay. Is that a document that
It's an old document.
Right.
I mean, we produced it to you, so I would have seen it, but it's not a current document.
Okay. Look, so it's a document he was provided with, and you can see then on the left-hand side, well, first of all, it's saying, do you know of a case of sexual misconduct by a member of a health profession, in a sense attracting attention to the fact that the HCCC is able to deal with it, and it's certainly this document that has led AWC to think he came to the right people to deal with his complaint.
Yes.
You can see on the left-hand side those ticks were in fact made by AWC, indicating what it is that he'd experienced, which is the sexual assault, inappropriate examination and inappropriate treatment.
Yes.
Now, AWC has said the last page of the leaflet stated that the HCCC does not have any jurisdiction over criminal matters. Lawyers within the HCCC will advise if a complaint should be referred to the DPP for action. So if you could scroll to the fourth page of that document, please. There you go, at the top right-hand corner there. The Healthcare Complaints Commission does not have any jurisdiction, etc., but will advise if a complaint should be referred to the DPP. Now, I certainly understand this is not a document that you created, and it's not a document that's with the Healthcare Complaints Commission being promoted at the moment, but back then this was a document that suggested that you'd come to the right place with the Healthcare Complaints Commission.
Yes, and I heard that evidence and how pleased and relieved he was to find someone who he thought could do something about it. And even worse, to be putting that out there and then dashing in practice that confidence and that relief that he felt that it would be pursued.
And it's also in that last page there, it's suggesting to him, and if we think you need to go to the police, we'll let you know. So it's sort of taking that responsibility away from the complainant, because we'll let you know if it needs to go further than this.
To the DPP, you mean?
To the DPP, yes.
Yeah. Well, I think that's a reference to Section 39. At the end of an investigation, the Commission had a power to refer the results to the DPP.
Yes.
And that was the only explicit power, I suppose, of referral. When I started, I did refer a couple of things to the DPP at that stage, and they just sent them to police. And then I got a call from the police saying, what am I supposed to do with this? So the arrangement with the MOU and the Section 99A disclosure that we talked about before sort of superseded those, both Section 26 and the 39 one, which were old ways of doing things. It's most effective for police to be taking up investigations on the DPP.
Yeah. Thank you. Now I'm just going to take you to page 47 of your statement, Mr. Pem, and this is the part of your statement that you do talk about the current policies and practices regarding child sexual abuse. And from what you've said so far, a lot of what you've set out in your document there post-dates the sort of institutional responses that we've been looking at to date.
Yes.
Now, at page 48, at paragraph 188, you've set out the role of the assessment officer. Again, I've already asked you about that in terms of the support and the training and the experience that an assessment officer has in relation to dealing with people who might be traumatised or emotionally fragile in any way.
Yes.
We've also raised the issue, you've listed 4 dot points there, and you've raised the issue there of referral to another body, which of course might be the police, which is available at the end of the assessment process.
Yes.
At paragraph 190, and towards the end of that paragraph, you've said, if the complaint raises possible criminal offences, the HCCC's current practice is to discuss the matter with the complainant, advising and encouraging them to report the matter to the police.
Yes.
Yeah. And that's the default position currently.
Yes.
On page 49 of your document there, at paragraph 194, you've said pursuant to section 27, subsection 1F, the Healthcare Complaints Act, the HCCC has a discretion to discontinue dealing with a complaint if it involves events that took place more than 5 years before the complaint was made.
Yes, and I know
And again,
that doesn't include.
I don't mean to
without
be
reasonable
pedantic here,
excuse.
but there's an incredibly important part missing there, isn't there?
Yes, yes.
At paragraph, on page 50 at paragraph 198, at the end of that paragraph you've said, investigation officers are also to ensure their correspondence is adapted appropriately and thoughtfully, having regard to the intended recipient. Now, how does that happen?
Well, that's probably been one of my ultimate failings in the Commission. I mean, my view has always been that you should write a letter knowing who you're speaking to and pitched at a level that they'll understand and appreciate, and acknowledging the communication you've had. Mm-hmm. People just seem to have a chronic reliance on standard letters, and I would redraft letters and then I'd find paragraphs that I'd redrafted turning up in standard letters in other places, and I sort of lost that battle. That's why we went the route of doing the explanatory fact sheets that set out. We stuck with the form legalistic letters, but the attached fact sheets are much clearer and plainer and explain in plain English what all of those sections and technical things mean in practice.
Okay. And again then at paragraph 199 there, for complainants where the outcome has resulted in death, significant trauma and or life-changing circumstances, that the level of engagement with the complainant will be significant.
Yeah.
Again, just in terms of staffing and resources, what kind of support do the officers get in relation to having a file, for instance, where the complainant is highly needy and they're taking a lot more time? Is there just an allocation to a certain number of files and they've got to find the time to deal with a needier, more intensive?
No, that's why we implemented the team structure, and that's why we have the case management system now, so we can get regular reports on files. The team structure allows people to raise those issues, have team meetings, they can discuss difficulties they're having with workload or with particular complainants and how they're coping with the load. So there's more sharing of experience, so more peer support. It was the case that it was very much investigation officers were handed a file load and expected to deal with them with very limited supervision, without much support.
Mm-hmm. Thank you. Your Honour, I see the time. Would you like me to continue with Mr.
Well, how much longer will you be?
Look, I probably won't, only about another 10 minutes.
What about the rest of the bar table? Are there many questions to come?
I have some questions, Your Honour.
I do as well.
I anticipate some also.
I thought you might. I think we'd better come back tomorrow morning. Just before we adjourn, though, you spoke of something in the order of 5,000 complaints a year. How many of those would relate to sexual assault, and then how many might relate to sexual assault of children?
I was just looking that up earlier, and it's 1.3% of complaints fall into the category of sexual misconduct, so 101 out of 5,000. There's another category of boundary violation, which
that would be sexual assault, including adults as well as children.
Yes, and I've tried to search for the actual number of child sexual assault, but I can't get an accurate reading. I bet it would be a very small number.
Yeah.
Rolleston is the only case of a medical practitioner, and there are 2 dentists, both of whom ended up being prosecuted and being cancelled. And they're the only ones that I'm aware of there where this is analogous sort of conduct.
All right, 10 o'clock in the morning.
Thank you.